and time to time many laws are amended means many other rules and regulations are also added, and corrigendums are also created. Okay, so it deals according to the time also. Okay, so in block 1, 4 units are there. In unit 1, it will explain the meaning of contract and its classification. You need to know that what is the contract, actual contract, what is that, and how many types of contracts are there, you will get here. And it will also give the glimpse of, or it will discuss about the essentials of the valid contract, which is important part in this chapter. And you will see that in block 1 and block 2, the whole thing of essential of valid contract is discussed. The same thing is discussed in both the block 1 and block 2. Okay, so in unit 1 only, just it will give you the meaning, what are the essential of valid contract, sorry. And in details all the chapters, that is in unit 2, unit 3, and it will continue in block 2 also. Then unit 2 it will describe you the rules relating to offer and acceptance. You have to know what is offer and acceptance also. Okay, here as you are in under UG, so here don't think that what is the meaning of offer will come or what is the meaning of acceptance will come. Okay, you have to understand what is the concept of offer and acceptance. You have to understand, and as per that you will get the question and you will write accordingly. Okay, and here also their communication and revocations are also mentioned. Then you will see in unit 3, it will deal with the capacity of parties. How many parties should be there? Okay, you know that in any contract or any deal, whatever dealings are being done, minimum 2 parties should be there. Like that, how many parties in which type of contract it is given. And it will discuss the position of a minor, a person of unsound mind, sorry, and the person disqualified from contracting in relation to contracts entered into by them. Okay, so what are the laws relating to them? It will discuss in unit 3. Then in unit 4, you will see that the concept of free consent and describes the effect of coercion, then undue influence, fraud, then misrepresentation and mistakes on the validity of contract. You will get this. Okay, so in unit 1, this is the structure what you will get. Okay, so objectives you will study, it is, you can easily go through it, you can easily understand. Then introduction part, then what is law is given, then meaning and sources of business law. What are the sources of business law? Like other laws are being prepared, and you know that many of the laws are being taken from the other countries also. Okay, how other countries are dealing with the particular field and how they are creating law. So sources, main sources that comes from other country also. Okay, and some of the laws are created in India by seeing the situation also, what will be done for the current situation, that will be, that is seen. Okay, but basically what sources are there, it is given here. Then what are the law of contract? Okay, then what is contract? So as per the contract, what is agreement, legal obligation, and difference between agreement and contract is given here. Then again, contracts are classified into various groups, that is on the basis of creation, on the basis of execution, on the basis of enforceability. Okay, each and everything you have to understand the meaning, what is the concept, that's all. Okay, then most important part of this unit is essentials of a valid contract. You have to read that. Okay, so law you have understood. So here definitions are given. So definition, as per the definition, when you are writing the definition of any term, kindly mention the name of the, sorry, whatever definition is given, who has given that definition, you have to write. Okay, So name and definitions are important. So here various definitions are given. Whichever is suitable for you, you can refer that. Okay. Then sources, as I was telling you, sources of business law. So here you can see English mercantile law is there. This is the source. Means from where the law are being created or taken. Then Indian statute law, then judicial decisions are there. Okay, judicial decision means sometimes some cases are there in court. So under which many new laws can be created. So in that process, whatever the situation are there, new situation arises within time to time. So as per that also new laws are created. Then customs and uses also there. Okay, go through that. All the, it is not possible me to read out all the paragraphs within 1 hour. So go through it. You will get the materials from the website. Then what are the law of contract? Okay, so law of contract is contained in Indian Contract Act 1872. Okay, which is mentioned here in this paragraph. Then definition of contract, again it is given here, you can go through it. Then agreement, how you will know that particular contract is under the agreement. So here it is, one simple equation is given there, that is agreement is equals to offer plus acceptance. Okay, that means unless and until any person is offering some deal or offering some proposal, there does not arise any agreement. And unless and until the offer is accepted, there does not arise any agreement. Okay. Then come to legal obligations. Legal obligations are mentioned here. That is, law of contract is concerned only those obligations which arise out of agreement. Okay. And which should be, the agreement should be approved by the law. Okay, that is legal obligation. If it is not approved by the law, court of law, if it is not approved, then that is not any agreement. That is void one. Okay, so here again, difference between agreement and contract is given. Then come to classification of contracts. So there are three groups are there, three categories are there, groups or categories you can see. On the basis of creation is there, in which again it is subdivided, that is express contract, implied contract. Then on the basis of execution, that is executed contracts, then executory contracts. Then third one is on the basis of enforceability, in which valid contract is there, void contract is there, and voidable contract is there. Okay, here you can see in every type of contract there is an example. Go through that example, because in many of the questions I have seen that some examples are given, question is given, that some kind of example is given, and you have to identify or you have to clarify that whether it is a particular type of contract or not. You have to distinguish that. Okay, so go through the examples so that you can know that which example comes under which contract. Go through that. Then voidable contract is there. Then some of the difference between void agreement and voidable contract is given. Then illegal or unlawful contract, by the name itself you can know that what type of contract it will be. Okay, then again differences are there, void agreement, illegal agreement, how it is different. Okay, void is not just illegal, void is just it is cancelled. Okay, in simple language, if I'll make you understand, then void agreement is different from illegal agreement. Okay, then unenforceable contract is there. Then in the given chart, it is well classified how contracts are being classified under various groups. You can go through here. Then essentials of a valid contract. This is the important part. So there are usually some of the website, they will show only 7 essentials of valid contract. Okay, so many website will show you 7, but 10 also is given. So same essentials of valid contract will be shown. Okay. So if suppose examples are not cleared here in this study material, if suppose some of the examples are not clear to you, so you can go through some websites also. There you can easily get that. Okay. So out of this 10, first one is proper offer and its proper acceptance. There is a certain protocol for the offer and acceptance. Okay. Then second one is intention to create legal relationship. So keep in mind that whatever agreement or whatever offer and acceptance is done, it should be legally accepted by the law. Okay. Then free consent is there. Then capacity of parties to contract, lawful consideration, lawful objects is there. Agreement not expressly declared void. Then certainty of meaning, possibility of performance, legal formalities. Okay. So same thing is being explained here. And if you will go to next unit, some questions are there here. Next unit, the same essentials of the contracts are explained here. Okay. So next unit, you will get that offer and acceptance. What are the objectives and its introduction, and what is offer, how is an offer made, to whom an offer is made, legal rules for valid offer, cross offers, standing offers. All these you will get here. Okay. So again, I will tell you that go through it and understand the concept. Okay. Because whatever it will given, direct question will not come. Okay. So go through the concept so you can understand the question, that what is about that. Similarly, here you can see after offer, acceptance. What is an acceptance? Who can accept? How is an acceptance made? Then legal rules for a valid acceptance that you will get. Then communication of offer and acceptance. Communication of offer, communication of acceptance, contract over telephone or mobile. Okay. Then revocation of offer and acceptance. Under that, revocation of offer, revocation of acceptance, communication of revocation. Then how the offer can lapse. That is also mentioned here. That is lapse of an offer. So you can see here what is offer, meaning it is given here. So offer, any proposal you will make to any person. Okay. So here one more thing I forgot to tell you, that whatever you will explain, please kindly mention the sections also. Okay. Sections are important here. Sections you will mention and explain whatever you want to. Okay. And go through the examples, as examples are given in each and every part. Then how offer is made. So here offer is made in two ways, that is express offer, implied offer. Okay. So express offer is just for words spoken or written, and implied offer is made for words spoken or written. Okay. Then to whom an offer is made. Okay. So it is for a specific person or in general. You can see that here. So they will choose some person. Okay. Then come to legal rules of valid offer. What are the rules? So first rule is that offer must intend to create legal relation. Then terms of offer must be certain, definite and not vague. Okay. Then to offer must be distinguished from a mere declaration of intention. And then offer must be distinguished from an invitation to offer. Go through the examples again. Then offer must be communicated. Some cases are explained here also. You can go through it. So here more are given, that is offer should not contain a term the compliance of which would amount to acceptance. Then special terms or conditions in an offer must also be communicated. Then come to cross offer. Cross offer is a cross offer do not amount to acceptance of one's offer by the other, and as such no contract is concluded. Okay, so here again the example is given, go through the examples. Then again standing offers are there. Then come to acceptance. When offer is made, acceptance also should be there, then only agreement is possible. Okay, so what is an acceptance? Then who can accept it, how it is accepted, or how is an acceptance made, then what are the rules of a valid acceptance. Okay, rules are there, go through the rules, particularly rules are important here in each and every part. Then these are the rules, 6 rules are given. Then communication of offer and acceptance. Okay, how it is communicated. So come to communication of acceptance. Here again meanings are there, you can go through it. Then come to revocation of offer and acceptance. How it is revoked, that is taking back or withdrawn. Okay, so in which cases or what are the rules? Okay, rules of revocation. That means if offer and acceptance is already made, and after that if certain cases arises or any situation arises, it can be withdrawn, it can be void, or it can be taken back. Okay, then revocation of offer, how it can be taken back, it is mentioned here. Then revocation of acceptance also is taken back. Again, whatever sections are given, go as per these sections you will write the meaning. Okay, then communication of revocation, then lapse of an offer, how it will be lapsed. Okay, when any offer is made, at which time it can be lapsed. Okay, before the acceptance, it is given here, you can go through, it is easily understandable. Then come to third unit, that is capacity of parties. Capacities of parties, what are the objectives, then introduction of that, then who is competent to contract, that means who can enter into contract, that means there is a particular age limit or there is a particular state of mind also. Okay, and certain things are also mentioned. Then who is minor, then position of agreements by a minor, under minor condition what are the rules and regulations of an agreement. Okay, then come to agreements by persons of unsound mind. So under this category, how the agreements are being taken into consideration. Okay, so then again person disqualified by law, which person is disqualified by law, who cannot enter into the contract or is not qualified for the agreement. Then unit 4, that is free consent. What are the objectives? Again here, again meaning is given. So meaning of consent, that means you are allowing or you are giving the agreement, you are agreeing with someone, consent. Okay, so what is the concept of free consent? Then factors, what are the factors affecting free consent? Okay, here it is given, that is coercion, meaning it is given, meaning is clearly mentioned here, go through the meanings. Then coercion is there, see the table here as per. Then undue influence, coercion is there, that is voidable, that is undue influence. Then fraud, misinterpretation, then mistakes. So factors are affecting of free consent. Okay. So here you can see some of the points are given: effect of coercion, then burden of proof, then all are explained here. Go through the points and examples also. Then this is the last unit and of this block 1. So let me go to all the other things are explained here. Just go through it. Only difference between are given and explanation of such factors are given. So you can go through it. Then come to next block. This is block 1 up to unit 4. Then come to block 2. So in block 2, again it is the part of second part, that is general law of contract. Second part is given. Here you will get consideration and legality of object. Then unit 6 you will get void agreement and contingent contracts. Same here you can see that if you will go through that essentials of law of contract, the same points are again explained in a vast way. Okay. So then unit 7 performance and discharge, and unit 8 will show you remedies for breach and quasi contracts. Okay. Every terms if you will not understand here, you can search it in Google. Everything you will get there. Okay. So again in a very brief way, what is explained here you see. Unit 5 will explain you the meaning of consideration and rules for a valid consideration. It also describes the concept of public policy, lists of agreement opposed to public policy. Then unit 6 deals with agreements which have been declared void and also discuss the rules relating to contingent contracts. Then unit 7 will be discussed about the rules relating to the performance of contract and describes various modes of discharge of a contract. Then unit 8 will describe the meaning of breach, types of breach, and various remedies available to the aggrieved party. It also lists the relationship resembling those of contract, that is quasi contract. Okay. Now first, that is unit 5, it will give you the glimpse of consideration and legality of object. Objectives are there. What are the objectives? Then introduction of the same term, then meaning of consideration. So meaning of consideration in example it is given example. So as per the Indian Contract Act 1872, which section will explain consideration, that you have to see, and if you will explain some of the examples, that will be better. Okay. And as per this concept, if some questions will come, you can explain according to this concept. Okay. Then legal rules of valid consideration. So some rules are there, you see. Rules are important, so go through the rules. Okay, rules are important here. So various rules are given. Some of the rules I will read out the head points only. That is, consideration must move at the desire of the promisor. Okay. Then consideration must move from the promise or any other person. With an example it is given, case study it is given. You can go through it. Examples are there given again. Then consideration must be of some value. Then come to consideration must be legal. Then stranger to a contract and stranger to consideration. This is also one important one. So how a contract is made with the stranger. Okay, in many of these situation or cases, contracts are being made with the strangers, not with the family members or known person. Most of the cases, contract is done between the unknown persons. Okay, which can be either at the time, at any time, it can be void. Okay, so some of the examples are there. And come to adequacy of consideration. Examples are only given here. Then legality of agreements without consideration. So what are the legal formalities? That is as per the Contract Act. What section, which section will explain you what you can see here. Then come to legality of object and consideration. Again, by seeing the examples, you can understand the situation or any statement if it is given in question, you can explain that. Then come to agreements opposed to public policy. Okay, some of the agreements are there which will oppose by the public policy. There also agreement can be taken back or it can be void. So you can see here heads of public policy. What are the policies are there? You can here see trading with enemy is given. Okay. So then agreements for stifling prosecution. One case is mentioned here. Okay. Then contracts in the nature of champerty and maintenance. All the examples are there. You can go through the examples. Many points are given here. Then come to next unit, that is void agreement and contingent contract. Okay, what are the agreements which comes under void condition or void agreements and contingent contracts? There are many other contracts are also there. So directly come to void agreements. Here you see many points are there. That is, the following types of agreements have expressly been declared void. What are the void agreements? You see many categories are given under which section it is mentioned. This you will go through. Then agreements by or with person incompetent to contract. Okay, that is mentioned under section 10 and 11 of Indian Contract Act 1872. You can go through their details. Then agreement entered through a mutual mistake of facts between the parties. Section 20. Then agreements, the object or consideration of which is unlawful, which is mentioned in section 23. Then agreement, the consideration or object of which is partly unlawful, that is mentioned in section 24. Then agreements made without consideration, section 25. Then agreements in restraint of marriage. In that condition, what are the rules and regulations which are given in section 26. Then agreements in restraint of trade, that is given in section 27. Then agreements in restraints of legal proceedings, that is section 29. Then uncertain agreements. Then wagering agreements, which is given in section 30. Then impossible agreements are given, that is section 56. Okay, so here you can see agreements in restraint of marriage. What are the conditions? What are the situations under this category? You will see here. Okay, then agreements in restraint of trade. Okay, so it will not allow any tendency to impose restriction upon the liberty of an individual. Okay, unless and until any court will object, there is a liberty to trade or liberty to create an agreement. Then some examples are given. Then statutory exemptions are there. Legally, some exemptions are there. That is sale of goodwill. Okay, you can sell the goodwill under section, what is given under section 27, it is mentioned here. Then certain restraint in partnership also. Then under judicial interpretation, some of the points are given. You can go through it. Then come to agreement in restraint of legal proceedings. Okay, while legal proceedings, what can be objections or what can be the obstacles there that you will get here? That is a restriction on legal proceedings, how it is Done here. It is explained here with an example. Example is also mentioned here. Then limitation of time is also there. Then uncertain agreements. Uncertain agreements are there. Then wagering agreements. Under that, various points are there, which is essentials of wagering agreement. Some points are there, 5 points are there that you will go through it. Then effects of wagering agreement. Under that, what type of cases are there? All cases are explained here. Then exceptions are also there. What are the exceptions? Then agreements to do impossible acts. Okay, some of the acts are impossible. So impossible acts itself is a void one. So in that condition, how agreements are made? Here briefly it is explained. That is, here examples, you will see the examples, you can understand. Then contingent contracts. Contingent contracts you will see here. Contingent contract, again it is explained here. It is contract to do or not to do something if some event or collateral to such contract does or does not happen. Okay, that means it is uncertain that some event will happen or not. In that condition, what are the contingent contracts? So rules regarding enforcement of contingent contracts. What are the rules? Here rules are there. That is, the rules regarding contingent contracts are given under, that is section 32 to 36. It is explained there. Go through it. Then difference between is given. Difference between a contingent contract and a wagering agreement. Sorry. Then next unit, that is performance and discharge. Okay. So objectives come to directly meaning of performance. What is that performance? Okay, it means that parties to contract have fulfilled or carried out their respective obligations. Okay, if suppose one example I'm reading out here, you can see here performance, a contract to sell his book to B. A contracts to sell his book to B for ₹50. Okay, so A delivers the book and B makes the payment. The contract is discharged by performance. That means all the activities are done successfully. That comes under, that is the meaning of performance. Okay, as per the section 37, meaning of the performance is given. So what are the types of performance you see? So there are two types of performance, that is actual performance and attempted performance. Then kinds of tender. So tender of goods and services. Then tender of money. So what are the essentials of a valid tender? So it must be unconditional. It must be made at proper time and place. And in case of tender of goods, it must be a reasonable opportunity to the promisee of ascertaining that the goods offered are the same as the promisor is bound to deliver. Okay, so it must be for the whole obligation. It must be made to the promise or his duly authorized agent. Then in case of payment of money, tender must be of exact amount due, and it must be in the legal tender. Okay, these are the essentials of valid tender. So in each and every part you will see the essential points are given. Okay, so essential points are important. Just go through that. Sorry. Then effect of refusal to perform promise wholly. What are the effects? You can see here. One example is given. Then who can demand performance? Okay, so here are some parties who can demand promise. First one is promisee, the one who will promise. Okay, then legal representatives of the promisee. In which condition legal representatives can be there? In case of death or in case of a person of unsound mind. In that case, legal representative can claim. Then third party. Okay, third party can also demand the performance. Then joint promises. If joint promises are there, in that case also performance can be demanded. So who must perform? That is promisor himself, then promisor or agent, then legal representative, third persons, performance of joint promises, all they can perform. Okay. Again, examples are there. Examples and case studies are given. Go through that. Then time and place for performance. Okay. So it is also important. So what will be the time and place for the performance is also taken into consideration. So first point explains that performance of a promisee within a reasonable time. Time should not exceed to particular time period. Okay, it should not take a long time period which is unacceptable. Then performance of promisee where time is specified. Then performance of promise on an application by the promisee. Then performance of promise where no place is specified and also no application is to be made by promisor. Performance of promisee promise in the manner and time prescribed or sanctioned by promisee. Some examples are there. Then time is the essence of the contract. Okay, time is the important part of a contract. Why it is important? You can see here. It is taken into consideration because if time of certain contract is over, no contract can be made. Okay, contract should be made within a particular period of time only, and that's why time is taken most important part of the contract. So some explanations are given. Then performance of reciprocal promises. Reciprocal means just the opposite, turning around. Okay, so there are again types of reciprocal promises are given. So first one is mutual and independent, then conditional and dependent, mutual and concurrent. Okay, so mutual and concurrent means there will be have to perform their promises simultaneously. Okay, at the same times performance should be conducted. Then what are the rules? Again, rules are important here. Rules you will see. So first rule is that mutual and concurrent. As per the section 51, it is explained there. Then mutual and dependent. Okay. Then mutual and independent. Then order of performance of reciprocal promises. Here you can just go through the rules only. Okay, and others you can just go through it. Some examples are given just to understand the concept. Then assignment of contracts. Okay, so assignment of contracts, here you can go through all the examples how assignments are done under various categories. Okay, so here first it is given by the act of parties and by operation of law. So these contracts are assigned according to this category. Okay, so contracts will be assigned in first category, that is by the act of parties or by operation of law. Only examples are mentioned here. So you will see the examples. Then appropriation of payment, which is the most important again. Okay, every agreement, every contract is entered only for money, or that is payment only. So how payments are being appropriated? So where there is an express or implied intimation by the debtor. Okay, so in that condition, how it is implied you will see. Then where there is a no express or implied intimation, in that case what are the rules or laws? Then third, where neither party appropriates, in that case what will be the situation? Then come to modes of discharge of contract. What are the modes? So it is given in a chart form, you can see. So it is categorized under various groups, that is performance, mutual agreement, lapse of time, operation of law, impossibility of performance, and breach. Okay, it is clearly categorized here. So the same thing is explained below. So what is discharge by performance? Again here meaning it is given. So discharge by mutual agreement, in that certain ways are given, that is novation, and meaning is given, that is substitution of new contract, and examples are given under. Then rescissions, alteration, remission, waiver, all are just examples are given to make you understand. Then discharge by lapse of time. Okay, in which cases lapse of time can be considered, that is certain given period of time, if it is given, then it is over, then any contract will be void. Then discharge by operation of law, in that condition death of the promisor, insolvency, merger, material alteration. In that case, all the operations will be discharged or cancelled. Then discharge by impossibility of performance, where no performance can be held by the law, under the law. Okay, so in that condition, destruction of subject matter, then death or personal capacity, incapacity, then change of law, then cessation of a state of things, then declaration of war, in that condition also difficulty of performance. Then so here you can see difficulty of performance, in that condition, which condition it can be difficult to perform, with an example again it is given. Then commercial impossibility, default of a third party, strikes, lockout, civil disturbances, partial impossibilities. Then what are the effects of supervening impossibilities? Okay, then you will come to discharge by breach. Okay, discharge by breach means if suppose anything is discontinued. Breach means in simple language it is discontinuation or break. Okay, so it is of two, in this it arises in two ways, that is actual breach and anticipatory breach. That means actual breach will arise, then anticipatory means you have imagined, just an imagination, or that is predicted one. So in unit 7 that was all about. Then come to unit 8, that is remedies for breach and quasi contract. Okay, so if contract is broken or discontinued, okay, if any contract is not able to be taken, so for that also some remedies and some solutions are given. So that solutions are given in unit 8. Okay, so these remedies, if suppose some question will come, that any question related to breach or quasi contract, how it can be solved, okay, how it can be rectified, it is mentioned in unit 8 of block 2. So first of all, you have to understand what is the meaning of breach of contract. Okay, so here as per the section 2C, meaning is given, that means if suppose any contract is failed to be taken forward, or if any contract is broken or discontinued at any moment, okay, that is the breach of contract. Then anticipatory of contract, that means that is predetermined. Okay, that means that is predicted one, that is actually not happened, that is anticipatory breach of contract. If suppose contract, before entering into contract, if someone has predicted that contract can be discontinued in future, so in that case what are those, it is explained here with an meaningful examples. Then actual breach of contract, actually whatever it is happened. Okay, In two categories, you will see the remedies in case of anticipatory breach and in case of actual breach. Here you can see. Okay. So some of the remedies or solutions you can say remedies for breach of contract. In this you can see here rescissions of the contract, then suit for damage, suit for specific performance, suit for injunction, and suit upon quantum merit. Okay, so here you can see first one is just every remedies you will just claim. Okay, everything you can see here: suit for damage, suit for specific performance, suit for injection, suit upon quantum merit is given. So everything you have to go through the law or legally you have to sue. Okay, if suppose any contract is broken or discontinued, so as per this law, as per these remedies, you will categorize that contract under which type of contract the contract is breached. So as per that only you will just apply these remedies. Okay, so you will in this case you will just try to categorize the statement that under which category such type of contract has been arised and breached. Then only you can find out the remedies, so that remedies will be applicable to type of particular type of breach. Okay, so everything is here explained, and you can see some remedies are explained. Then suit for injunction, quantum merit, then quasi contract. So quasi contract you can see here that a contract in law but in not in fact. Okay, so quasi contract is it is given in law but not in fact. Okay, but in not in real, you can say it is fictitious which you can just imagine. Okay, quasi contract is just imagined one, fictitious, which you can't see, which you can't touch also. Okay, so under this, first you will see the difference between quasi contract and contracts. Then types of contract, quasi contracts are given. So in that, that is supply of necessaries, that is not important. Then here you can see obligations for non-gratuitous act. In that also rights are given, liabilities are given. Then quantum merit. Okay, quantum merit, under that the claims of quantum merit. In that case what you will claim. Okay, and in which cases you can claim, it is given here. Okay, sorry. Quasi contract, then quantum merit. Okay, so claims of quantum merit, certain points are given. So here in study material you can see here questions are given, you can just practice that questions. In this study material you will get everything. Okay, so you can depend on this study material. So this is all for today. If you just go through that, go through all the points, and if you have any doubt just write it, and next class we will discuss about that point, because here I am not a teacher, I will not teach you, but I will guide you how to study. Okay, so whatever doubt you have you can ask me in next class. So if you have any doubt now you can ask me. So okay, let's end the class. Thank you all.